Good afternoon. Welcome to Long Live Third Parties Podcast. Free Press Media Press Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Libertarian Party of Colorado versus Williams, 405 P3D1159, Colorado Court of Appeals, 3rd Division, 2016. Friends, today this case is something that's secondary to ballot access, the focus. Yet, because it has a link, however secondary, to ballot access, we want to discuss it because this is part of our battle. This case briefly mentions the ballot access trial, and the vast majority of it pertains to a secondary issue that stems from the initial ballot access trial. So let's read from the record to see what happened. It says, quote, the Libertarian Party of Colorado and two recall election candidates, Richard Anglin and Gordon Roy Butt, sued Wayne Williams in his official capacity as the Colorado Secretary of State, Chuck W. Bruman in his official capacity as the El Paso County Clerk and Recorder, and Gilbert Ortiz in his official capacity as the Pueblo County Clerk and Recorder, collectively the Secretary, alleging that the statutory deadline for filing candidate petitions conflicted with the Colorado Constitution. The Libertarian Party also asserted that the statutory deadline violated its First and 14th Amendment rights, and it sought declaratory and injunctive relief, but not damages, under 42 U.S.C. Statute 1983 and attorney fees under 42 U.S.C. Statute 1988. The District Court granted relief on the state's election claim, but did not address the 1983 and 1988 claims. On the Libertarian Party's motion for summary judgment on its federal claims, the court ruled that its judgment on the state election law claim, coupled with the Supreme Court's order denying review of the state claim, constituted a final adjudication on the entire case. Alternatively, the court ruled that the Section 1983 and 1988 claims were moot because the General Assembly had since amended the offending state statute. Accordingly, the court denied the Libertarian Party's summary judgment motion and dismissed the remainder of the case. The Libertarian Party appeals. End quote. As you can see from those two paragraphs, this case is a technical case. I mentioned earlier, this case is not centered on ballot access the way many of these other cases are, but it does have a relation to ballot access because that's the thrust of why this case happened in the first place. And the secondary issues play a role in ballot access. In this case, the Libertarian Party wants to get return of their attorney fees. And that indirectly helps them because it means more money for the cause if they can get the attorney fees. Again, our friends at the Libertarian Party are invoking the First and 14th Amendment. By now, for those loyal listeners out there, you're sick of me saying that. Every trial almost, not every single trial, but the vast majority of trials, our side uses that strategy of invoking those First and 14th Amendments. So that's something we want to focus on. If we deem this to be a good strategy, we want to continue it. They mention El Paso County. Don't confuse this with El Paso County in Texas. I'm from Texas, so I'm constantly thinking of El Paso County in Texas. Some people might say that El Paso County in Texas is the more prominent county. So you might be inclined to think like I do when I hear that term. But in this case, and sometimes otherwise involving Colorado, think of El Paso in Colorado. I don't know how big El Paso County is in there. It's fairly sizable in Texas. Pueblo is a more major county. Much of this case centers around the notion of attorney fees and mootness and a lot of technical legal issues. It's not so technical that I can't make any sense of it. It is technical because it's not focused on the issue at hand so much as it is secondary issues. the crux of this is the attorney fees issues which we discussed. It would be nice if the Libertarian Party could get them back. Ultimately, the court doesn't make a final determination here, but it does do something good. It says, quote, "Therefore, we remand to the district court to make findings and conclusions on these questions without taking additional evidence," end quote. And then, in the conclusion section of this case, it says, quote, "The judgment dismissing the Libertarian Party's claim for attorney fees under Statute 1988 is reversed. The case is remanded for the determination detailed above. In all other respects, the district court's judgment is affirmed," end quote. So this case mentions the Libertarian Party won the first time. It doesn't belabor that point, but it does mention it. So that's a good thing. And also a good thing is now that this case is being sent back to the original district court, our friends have a chance of winning their attorney fees back. So that's a great victory if they can get that. Not only do they win some of their points in the case, but also they can win the attorney fees. Way to go, Libertarian Party. We like to see this. Long live third parties. Goodbye.